We all understand that driving under the influence is dangerous and costly, but did you know that driving drunk kills 37 people a day in the United States? To put that into perspective, that is one person every 39 minutes. Driving while under the influence is a costly risk to public safety that puts innocent lives at stake, and in recent times holds bars, restaurants liable for over-serving intoxicated guests. Dram shop laws are statutes that hold bars liable for negligence caused by intoxicated person that could result in car accidents, injuries from fights, and even death. This could end in costly payouts if the restaurant or bar is found guilty. For example, on November 17, 2010, a St. Clair County Circuit Court judge found the defendant guilty of driving while intoxicated after leaving a strip club and hitting a truck on the freeway, ultimately killing one woman and injuring her husband. Under Illinois dram shop law, the plaintiff was awarded $37.5 million. To understand dram shop laws, we need to understand their history and evolution to present-day law. Dram shop law did not exist in the capacity in which it does now. Dram shop law originated from English common law. In the colonial times, there were no laws concerning how much alcohol should be served. In fact, the law stated that there were no limits on alcohol and patrons could consume as they wish. A tavern could be fined for not allowing a patron to consume as much as they wanted. Common law did not hold anyone liable in the event of a third-party injury as a result of an intoxicated person. This was for two reasons. First, adults were considered responsible for their own actions, and second, the injuries due to the actions of an intoxicated person were beyond the scope of foreseeability. In the mid-19th century, the law started to change with the temperance movement. Temperance, as defined by the dictionary, is abstinence from alcoholic drink. Supported largely by women because alcohol was viewed as something that destroyed families and marriages, temperance societies formed and pushed their beliefs of higher morals for society to the national level. In 1892, the first statute restricting alcohol was established in Maine and became part of the United States Constitution as the 18th Amendment. Other states joined, and by 1919, this amendment was nationwide and alcohol prohibition began. The 18th Amendment made manufacturing, transporting, and distributing alcohol illegal. However, it did a poor job of defining intoxication and the penalties that would ensue. This triggered the creation of the Volstead Act in 1919. The Volstead Act was a set of rules created to enforce the 18th Amendment and noted that any beverage with a 0.5% alcohol or more was considered intoxicating, and only authorized persons could be in possession of alcohol, which included religious and medical purposes. It did seem that prohibition was working. Both consumption and arrests for disorderly behavior dropped, and the United States Brewers Association reported lower rates of hard alcohol consumption during this time. But what was gaining in popularity and a losing battle for the government was bootlegging, an illegal production and distribution of alcohol. In 1925, there were 30 to 100,000 speakeasies in New York City alone. It was not until the 1960s, with the popularity of automobiles, that the threat of driving under the influence, that the courts revisited the common law and the rule of non-liability. This was the beginning of dram shop laws that held bars, taverns, and restaurants liable for over-serving alcohol. The word dram refers to a unit of measure, which is equal to 3/4 of a teaspoon, and comes from the 18th century Britain when gin was sold by the spoonful or dram. A dram shop today refers to any commercial business selling alcohol, and under new laws, these businesses can be held liable for third-party injuries that result from an intoxicated person who was served at their establishment. By 1987, 28 states had signed on to establish liability for the sale of alcoholic beverages. Today, 42 states have some form of dram shop law except Delaware, Kansas, Louisiana, Maryland, Nebraska, Nevada, South Dakota, and Virginia. Dram shop laws are enforced by the state and are not at the federal level. This means the law can vary from state to state or not be enforced. The modern legal framework for dram shop laws can be complicated and difficult to prove. For example, how does a bartender know if someone drinks on an empty stomach or even intends to drive? What if they arrive at the bar already drunk? It is just as difficult to understand someone's tolerance and to keep track of every customer during a busy shift. For these reasons, it is imperative that prevention is put in place through the education of serving staff. In Illinois, the following criteria must be met to hold an establishment liable under dram shop law. Proof of sale of the alcohol to the intoxicated person. Proof of injuries sustained. The injuries sustained were the result of the intoxication. Proximate cause between the sale of the alcohol to the intoxicated person. In Texas, the plaintiff must prove that the patron was a minor, that the establishment overserved, it was clear that the patron was already intoxicated, and that the intoxication was the primary and foreseeable cause of the injury, and evidence is needed to back up these claims. Dram shop laws allow establishment owners or employees to be sued. If minors are served, employees can be criminally liable, and employees can be found guilty of civil liability and face large fines. It is no surprise that limiting the consumption of alcohol reduces violence, injury, and even death. In a study conducted on states that impose dram shop laws, it was reported that there was a median reduction of 6.4% in alcohol-related fatalities. In today's hospitality industry, safety and accountability are top priorities and are becoming increasingly valued. Additionally, outside pressure from society, from organizations like MAD, to reduce drunk driving is putting pressure on establishments that serve alcohol to act responsibly. Dram shop laws and liability impose an extra burden on bars and restaurants to ensure they remain safe and to avoid large payouts. For this reason, it is important for these types of establishments to carry dram shop insurance, but it may also be reasonable for limitations to be put on large recovery sums so insurance can remain competitive and available. Bars and restaurants will continue to thrive in popularity, and in some jurisdictions, it is the duty under the law to serve responsibly.